This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today, I'd like to talk about the concept of soft fraud when applied to people who defraud insurance companies. For reasons known only to governmental entities, some insist on categorizing fraud into both hard and soft fraud. By so doing, the governmental entities that so categorize fraud make one type of fraud less heinous and less criminal than the other. Fraud, whether categorized soft or hard, are criminal. And if a person is tried and convicted of fraud, both, whether hard or soft fraud, can be sent to jail for the same amount of time. The types of insurance fraud some call soft fraud are found in every type of claim presented to an insurer. Soft fraud, which is sometimes called opportunity fraud, occurs when a policyholder or claimant exaggerates a legitimate claim. According to the Insurance Research Council, soft fraud is far more frequent than hard fraud. Because of the frequency of soft fraud, it adds more to overall claims costs than hard fraud does. Soft fraud occurs when a policyholder exaggerates an otherwise legitimate claim, or when an individual applies for an insurance policy and lies about certain conditions or circumstances to lower the policy's premium. The reality is, soft fraud is a criminal violation and a breach of a material condition of every insurance policy issued in the United States. It contributes to increased insurance costs. As a result of increased insurance costs, millions of Americans cannot afford sufficient insurance coverage. One cannot commit an innocent or partial fraud any more than one can be partially dead. Once fraud is committed, the contract of insurance is violated and is voidable by the insurer at its option, and the crime has been committed. Soft fraud, in contrast, usually involves legitimate losses that are exaggerated by the policyholder. For example, if a person is in a car accident and files a claim with her auto insurance company but overstates the severity of the damage to the car, that is an act of soft fraud. The insured did not fabricate the accident or the underlying claim, but nevertheless committed fraud by not being completely truthful with the insurance company. Similarly, if an insured reports a legitimate burglary claim to his or her home, but adds to the claim 2 flat-screen TVs that were not there nor were they stolen to make up the deductible, that person has committed insurance fraud. Soft or hard, it violates the insurance contract and is a criminal act. In New Jersey, regardless of whether or not the fraudulent act is soft or hard, insurance fraud is a third-degree felony under New Jersey law. And if a person is charged with 5 or more acts of fraud, the charge can be elevated to a second-degree felony. This means that even if convicted of the lesser third-degree charge, the person perpetrating fraud may be facing up to 18 months in jail and a $10,000 fine. In California, violation of Penal Code Section 550, the insurance fraud statute, can result in up to 5 years in prison. So the discussion that follows describes the most insidious and prevalent types of soft fraud. First is padding. Padding is found when injuries or damages are exaggerated to increase a claim's value. It is what has been called an insidious type of fraud, difficult to detect and often considered harmless by insureds, claimants, police, and prosecutors. Padding can come in a variety of forms. In first-party claims, an insured is generally considered to be in the best position to know the value of the property for which he or she is making a claim. An insurer depends upon the insured to provide an honest description and estimate of the description and value of the property, and most courts hold an insured to a high level of honesty when reporting a loss to an insurer. Padding is found in property insurance when insureds inflate the number of items lost or destroyed, or exaggerate the value of items claimed damaged, destroyed, or stolen. This can be as simple as increasing the size of a stolen TV from 32 inches to 60 inches, from a cathode ray tube to a flat screen, from $100 cash to $500 cash, or from 2 pairs of jeans to 5 pair. According to the Insurance Research Council study, approximately 90% of the costs of insurance fraud are the result of claims padding. Claimants add damage, injuries, and fictitious passengers to their insurance claims. The other 10% are the result of organized accident staging rings. Because of the sheer number of offenders and the light sentences received by the few that are convicted, pursuing these crimes has not been a priority for law enforcement or for insurers. On a third-party claims, the padding can be as simple as adding a week of lost earnings that in fact was not lost, or allowing the doctor to bill for 3 visits not made, or going to a chiropractor who charges for x-rays not taken. Standard fire insurance, all-risk property insurance, package first-party property policies, and most third-party liability policies state that the policy is void if the insured intentionally conceals or misrepresents any material fact or circumstance about the insurance or a claim, whether before or after a loss. When an insured submits fraudulent invoices to inflate a claim, the insurer has the right under the policy wording to void the entire contract of insurance. The insured's argument that he was entitled to recover that part of his claim not supported by fraudulent documents should be dismissed out of hand. One cannot commit a small fraud any more than one can be just a little bit dead. An insurer that finds facts indicating fraud by exaggeration must prove the following to deny a claim. 1. The insured intended to overestimate the value of the property. 2. The overestimate is material to the investigation being conducted by the insurer. 3. The insured intended to deceive the insurer. And 4. The insured actually deceived the insurer to its detriment. A commentator once stated that the fraud and false swearing consists in knowingly and intentionally stating under oath that which is not true, or the statement of a fact which the party does not know to be true and which he has reasonable ground for believing to be true, and an evasion intended to mislead or a concealment may constitute a breach just as much as a direct falsehood. This was from Appleman's Insurance Law and Practice Treatise. Some evidence is convincing on its face. For example, 1, an insured's willful overestimate of value in a proof of loss is sufficient to prove intent to defraud. 2, an overestimate made with reckless disregard for the truth can also prove intent to defraud. Reckless disregard is defined as stating as a fact something about which the insured has no reliable knowledge. If, on the other hand, the insured makes an innocent overestimate, the policy will not be voided. 3, as the courts in Illinois have held for more than 30 years, fraud and false swearing is a question of fact for the jury, but it becomes a question of law when the insured's misrepresentations cannot in any way be seen as innocent. In a case called Lycos, the evidence presented at trial was overwhelming that the insured had committed arson and had sworn falsely in the presentation of his claim. 4, the U.S. Supreme Court has long held that false statements about the acquisition of insured property are material as a matter of law when the existence of an insurable interest or ownership is at issue in a case called Claflin v. Commonwealth, an 1884 decision of the Supreme Court that affirmed the trial court's instruction to the jury that the insured's answer concerning the matter in which he paid for the insured's goods was material as a matter of law, and if false, was fraud. The materiality of a misrepresentation or concealment of a material fact is usually a mixed question of law and fact that under most circumstances should be determined by the trier of fact. A misrepresentation will usually be considered material if a reasonable insurance company, determining its course of action, would attach importance to the fact misrepresented or concealed. Most courts have construed materiality broadly, emphasizing in their holdings that the subject of the misrepresentation need not ultimately prove to be significant to the final result of the claim. All that is needed is that it should be reasonably relevant to the insurer's investigation at the time. And that was the case in the Claflin case, where the fact lied about would not have changed the amount of the claim or its proof. But because he deceived the insurer, the claim was denied effectively. For instance, in a case called Fine v. Belafonte, a 1984 decision of the Second Circuit, the court held that materiality should not be judged by what facts later turn out to be, but whether a false statement concerns a subject relevant and germane to the insurer's investigation as it was proceeding. Good cause fraud is another type of so-called soft fraud. Morally and criminally, insurance fraud is always wrongful. Many people within the insurance industry and outside it believe that because insurers are so well funded, that there are good causes for committing insurance fraud. A frightening trend is emerging where judges, jurors, and administrative law courts are refusing to convict or hold responsible perpetrators of fraud if the court is convinced that the fraud is for a good cause. This and other variations on the idea of soft fraud is considered the form of insurance fraud that is most difficult to detect, because soft fraud inherently involves a legitimate claim at its core. A perpetrator of soft fraud is not lying about the fact that items were stolen from him, for example. That is most certainly true. But he is lying about the item's worth or about exactly which items were stolen, sometimes even going so far as to say that certain items which he never actually owned were stolen. Soft fraud is also generally for smallish amounts of money and the overall lie is not very large or easily detected. After all, if the item was stolen, there is no easy way to verify how much it was worth, what it was, or where it was at the time of the theft. As a result, soft fraud often goes uncaught, unnoticed, and unpunished. This video was adapted from my book Insurance Fraud Volume 1 and is available as both a Kindle book and as a paperback from Amazon.com and from my website Zalma.com by clicking on the link to the Insurance Claims Library, where you can read about the 2 volumes of insurance fraud and all of my other books available either from Amazon.com, the American Bar Association, fastcase.com, or Thomson Reuters. If you found this video interesting or useful to you in your practice, please forward it to your colleagues. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can learn about future videos and blog postings. Thank you for your attention.